Examinations, appeals, and collections. A return may be selected for examination on the basis of computer scoring. A computer program called the Discriminant Inventory Function System, DIF, assigns a numeric score to each individual and some corporate tax returns after they have been processed. If a return is selected because of a high score under the DIF system, the potential is high that an examination of the return will result in a change to income tax liability. A return may also be selected for examination on the basis of information received from third-party documentation, such as Forms W-2 and 1099, that do not match the information reported on the return. Or the return may be selected to address both the questionable treatment of an item and to study the behavior of similar taxpayers, a market segment, in handling a tax issue. In addition, a return may be selected as a result of information received from other sources on potential non-compliance with the tax laws or inaccurate filing. This information can come from a number of sources, including newspapers, public records, and individuals. The information is evaluated for reliability and accuracy before it is used as the basis of an examination or investigation. The IRS must give reasonable notice before contacting other persons about tax matters. The taxpayer must be given reasonable notice in advance that, in examining or collecting tax liability, the taxpayer may contact third parties such as neighbors, banks, employers, or employees. The IRS must also give notice of specific contacts by providing a record of persons contacted on both a periodic basis and upon request of the taxpayer. Confidentiality privilege. Generally, the same confidentiality protection that someone has with an attorney also applies to certain communications that taxpayers have with federally authorized practitioners. Confidential communications are those that advise taxpayers on tax matters within the scope of the practitioner's authority to practice before the IRS, or would be confidential between an attorney and taxpayer, and also relate to non-criminal tax matters before the IRS, or relate to non-criminal tax proceedings brought in federal court by or against the United States. In the case of communications in connection with the promotion of a person's participation in a tax shelter, the confidentiality privilege does not apply to written communications between a federally authorized practitioner and that person, any director, officer, employee, agent, or representative of that person, or any person holding a capital or profits interest in that person. A tax shelter is any entity, plan, or arrangement, a significant purpose of which is the avoidance or evasion of income tax. Examination details. Taxpayers can make an audio recording of the examination interview. Their request to record the interview should be made in writing. They must notify the examiner 10 days in advance and bring their own recording equipment. The IRS also can record an interview. If the IRS initiates the recording, the taxpayer must be notified 10 days in advance, and they can get a copy of the recording at their own expense. Generally, a return is examined in the area where the taxpayer lives. But if the return can be examined more quickly and conveniently in another area, such as where books and records are located, a taxpayer can ask to have the case transferred to that area. The IRS tries to avoid repeat examinations of the same items, but sometimes this happens. If a tax return was examined for the same items in either of the 2 previous years and no change was proposed to tax liability, the taxpayer should contact the IRS and see if the examination can be discontinued. Appeal within the IRS. Taxpayers can appeal an IRS tax decision to a local appeals office, which is separate from and independent of the IRS office that is taking the action that the taxpayer disagrees with. The appeals office is the only level of appeal within the IRS. Conferences with appeals office personnel are held in an informal manner by correspondence, by telephone, or at a personal conference. A formal written protest is required in all cases to request an appeals conference, unless the case happens to qualify for the small case request procedure. Taxpayers may submit a small case request if the entire amount of additional tax and penalty proposed for each year is $25,000 or less. Some exceptions exist for an offer and compromise situation. Appeals to the courts. Preliminaries. If taxpayer and IRS still disagree after the appeals conference, the taxpayer may be entitled to take their case to the United States Tax Court, the United States Court of Federal Claims, or a United States District Court. These courts are independent of the IRS. For court proceedings resulting from examinations starting after July 22, 1998, the IRS generally has the burden of proof for any factual issue if the taxpayer has met these requirements. They introduce credible evidence relating to the issue. They complied with all substantiation requirements of the Internal Revenue Code. They maintained all records required by the Internal Revenue Code. They cooperated with all reasonable requests by the IRS for information regarding the preparation and related tax treatments of any items reported on the tax return. They had a net worth of $7 million or less and not more than 500 employees at the time the tax liability is contested in any court proceeding if the return is for corporation, partnership, or trust. The burden of proof does not change on an issue when another provision of the tax laws require a specific burden of proof with respect to that issue. Appeals to the courts. Tax court. The CP 3219N, the CP 3219N, is a notice of deficiency known as 90-day letter. Once a taxpayer receives this notice, they have 90 days, 150 days if the notice is addressed to a person who is outside the country, 90 days from the date of the notice to file a petition with the tax court if they want to challenge the tax that's being proposed. A case in the tax court is commenced by the filing of a petition. The petition must be timely filed within the allowable time. The court cannot extend the time for filing, which is set by statute. A $60 filing fee must be paid when the petition is filed. Once the petition is filed, payment of the underlying tax ordinarily is postponed until the case has been decided. In certain tax disputes involving $50,000 or less, taxpayers may elect to have their case conducted under the court's simplified tax case procedure. Trials in small tax cases generally are less formal and result in a speedier disposition. However, decisions entered pursuant to small tax case procedures are not appealable. Appeals to the courts, District Court and Court of Federal Claims. Generally, the district courts and the Court of Federal Claims hears tax cases only after the taxpayer has paid the entire tax and penalties and filed a claim for credit or refund. Again, generally, district courts and courts of federal claims hear tax cases only after the taxpayer has paid the entire tax and penalty and filed a claim for a credit or refund. That is different than the tax court, which would permit a taxpayer to have their case heard prior to paying tax. The taxpayer may litigate certain types of employment tax cases in either United States District Court or United States Court of Federal Claims. Before taxpayers can initiate suit in either of these courts with respect to certain employment taxes, they will have to pay at a minimum the employment tax assessment attributable to one employee for any one quarter and file a claim for refund of the tax. Once the claim for refund is denied or 6 months elapse without any action by the IRS, the taxpayer can initiate suit. Taxpayers can file a claim with the IRS for a credit or refund if they think that the tax they paid is incorrect or excessive. If their claim is totally or partially disallowed by the IRS, they should receive a notice of claim disallowance. If the IRS does not act on the claim within 6 months from the date the taxpayer filed it, they then can file suit for refund. Limit on amount of refund, injured spouse, and innocent spouse. If a claim is filed within 3 years after filing a return, the credit or refund cannot be more than the part of the tax paid within 3 years, including extensions, before filing the claim. If a claim is filed after the 3-year period, but within 2 years from the time the tax was paid, the credit or refund cannot be more than the tax paid within the 2 years immediately before the claim was filed. A refund may be reduced by an additional tax liability. Also, a refund may be reduced by amounts owed for past due child support, debts owed to other federal agency, or past due legally enforceable state income tax obligations. When a joint return is filed and the refund is used to pay one spouse's past due child support, spousal support, or a federal debt, the other spouse can be considered an injured spouse. An injured spouse can get a refund for his or her share of the overpayment that would otherwise be used to pay the past due amount by filing Form 8379. Someone is considered an injured spouse if they are not legally obligated to pay the past due amount and they meet any of the following conditions. They made or reported tax payments, such as federal income tax withheld from wages or estimated tax payments. They had earned income and claimed the earned income credit or the additional child tax credit. They claimed a refundable credit, such as the health coverage tax credit. If the taxpayer resides in a community property state at any time during the year, they can file Form 8379 even if only Item 1, which relates to not legally obligated to pay the past due amount, applies. In other words, in a community property state, they only need to not be legally obligated to pay the past due amount. Generally, joint and several liability applies on all joint returns. This means that both taxpayer and spouse, or former spouse, are liable for any tax shown on a joint return plus any understatement of tax that may become due later. This is true even if a divorce decree states that a former spouse will be responsible for any amounts due on previously filed joint returns. In some cases, a spouse will be relieved of the tax, interest, and penalties on a joint return. 3 types of relief are available. These all fall within what we would consider the innocent spouse group. The 3 types of relief: innocent spouse relief, separation of liability, equitable relief. File Form 8857, Request for Innocent Spouse Relief, to request relief. Collections, offer in compromise. Taxpayers may be eligible for an offer in compromise if they can't pay the amount owed in full or through installments. By requesting an offer in compromise, the taxpayer is asking to settle unpaid taxes for less than the full amount owed. IRS may accept an offer in compromise if IRS agrees that the tax may not be accurate, or taxpayer has insufficient assets and income to pay the amount due, or because of exceptional circumstances, paying the amount due would cause an economic hardship or would be unjust. Again, because of exceptional circumstances, paying the amount due would cause an economic hardship or would be unjust. For an offer in compromise to be considered, the taxpayers must pay an application fee and make an initial or periodic payment for all Form 656 submissions. However, low-income taxpayers may qualify for a waiver of the application fee and the initial or periodic payment. Collections, installment agreement. An installment agreement with the IRS means that they will allow a taxpayer to make smaller periodic payments over time if they can't pay the full amount at once. A setup fee applies to all agreements over 120 days. To be eligible for an installment agreement, taxpayers must file all required tax returns. Prior to approving the installment agreement request, IRS may ask the taxpayer to complete a collection information statement, Form 433F, 433A, and/or Form 433B, and also provide proof of financial status. If IRS approves the request, they will still charge applicable interest and penalties until the balance due is paid in full, and IRS may still file a notice of federal tax lien. Collections, statute of limitations. IRS can attempt to collect taxes up to 10 years from the date they were assessed. However, there are ways this time period can be suspended. For example, by law, the time to collect may be suspended while IRS is considering a request for an installment agreement or offer in compromise. Taxpayers live outside the U.S. continuously for at least 6 months. The tax periods being collected are included in a bankruptcy with an automatic stay. Taxpayers have requested a collection due process hearing, or IRS is considering a request for innocent spouse relief. Let's look at some questions. A right of privilege exists between a tax practitioner and client in many cases. However, the right to confidentiality does not exist in the following situation: where there's power of attorney authority. No, simply having power of attorney authority does not in any way negate the right of privilege. During collection activities, no, There's no reason that a right of privilege would not exist during collection activities. Tax shelter promotion. Yes, the right of privilege is quite limited in case of tax shelter promotion, in particular with written communications. That would be our correct answer, letter C. Then looking at letter D, an assessment letter response. No, there would still be privilege in the case of an assessment letter response. Nicholas wants his income tax case to be handled under the tax court's small tax case procedure. All of the following statements regarding the small tax case procedure are correct, except the amount in the case must be $50,000 or less for proceedings begun after July 22nd, 1998. That's correct. The amount must be paid before going to tax court. That is not correct. That, in fact, would be the answer to this question. This is not correct. The tax court must approve the request that the tax case be handled under small tax case procedure. That's right. The court does need to approve for it to be heard under those procedures. The decision is final and cannot be appealed. That is correct. That is correct. So the incorrect answer is right here, letter B. All the other answers are correct. And then finally, in regard to injured spouse and innocent spouse, which of the following is correct? Injured spouse and innocent spouse essentially mean the same thing? No, that's not correct. That's not accurate. Injured spouse is where there's no contention as far as the tax liability, but a refund is being held because of a past due amount owed by one of the spouses. And so the other spouse, who is considered injured, is asking for part of the refund. Innocent spouse has to do with one spouse being liable for the tax under joint and several liability. So they're very different. They're very different. They both have the name spouse in them, but they're very different. An injured spouse is requesting that they be relieved of a joint and several liability. No, that's getting things mixed up. That would be innocent spouse who are asking to be relieved of a joint and several liability. Injured spouse has nothing to do with joint and several liability. It has to do with a refund that is being held back because of some past due amount. So that is not a correct statement either. An injured spouse is asking that they are changed from married filing joint to married filing separately. No, that is not what injured spouse is about. Injured spouse is a jointly filed return with a refund where one of the spouses, and only one of the spouses, owes a past due debt, and the refund would otherwise be taken for that debt. Injured spouse is where the injured spouse is asking for some part of that federal refund. So this is not a correct statement. In terms of the question, this would be the answer we're looking for. But let's look at letter D also. An injured spouse is asking for their share of a joint refund when the joint overpayment is applied to a past due obligation of the other spouse. Exactly. That is absolutely what an injured spouse is all about. So the incorrect statement right here, letter C, the other statements are correct. All right. Thank you for watching this video. Hoped it helped you as you prepare for the enrolled agent exam.